Just wait for a minute. Yeah, we're going to call you back out. Your Honor, Tim Gibbs on behalf of Stephen Bullard, 20 CF 2839. Judge, I believe we reached an agreement with the state in this case. The state recommended that his current probation, for an admission, Judge, his current probation would be revoked and terminated, but he would be placed on a new supervision term of 6 months of community control. That would assess a $100 cost of prosecution, $150 public defender fee. That would also add a 7 p.m. to 7 a.m. curfew, and he would, of course, have to complete the original requirements from this previous term of probation.
It looks like he's on probation for drug charges, is that right?
Your Honor?
On probation for drug charges?
Yes, Your Honor.
All right, State.
Yes, Your Honor, that would be the agreement.
All right, Mr. Bullard, you're Stephen Bullard? Sir, you've had an opportunity to talk with your attorney. Is that what you want to do this morning, sir? All right, court then, he's going to admit the violation of probation?
Yes, Your Honor.
All right, he'll be adjudicated guilty of the violation of probation, and that probation will be revoked and terminated. I'm going to place him on a new supervision of 6 months community control with the following, with the original terms and conditions of the first probation reimposed on the community control. In addition thereto, he'll have a 7 a.m. to a 7 p.m. curfew. He'll be required to pay $100 cost of prosecution and $150 public defender lien. And he'll be adjudicated guilty of the was he adjudicated on the original charge?
I believe so, Your Honor.
Okay. If he hasn't been, he'll be adjudicated on the original case. So
Thank you, Judge.
Based on the curfew, if the court would be so inclined to give the probation office the authority to adjust that curfew as they see fit, especially if he has a job that requires him to be out past a certain time.
I'll go ahead and authorize that for job purposes, and then with notice to the state and defense attorney.
Thank you, Your Honor.
And to streamline this, if you want to, is he owes about $1,200. I don't know if he's going to be able to pay it. If the court would be inclined to say, if there are no other violations at the end, the money is just to go to collections. If not, we're going to turn around and do a violation report saying he didn't pay the money, and we're going to be right back here.
The state would not object to that, Your Honor.
We would request the same, Judge.
Well, I mean, does he have the ability to pay it, or at least a portion of it?
You know, I just lost my wife about 6 months ago, and before that, I nursed her in hospice for about 6 months, and before that, she was ill for about a year, in and out of the hospital. So my work has been, I had to stay home. So until I get my feet, that's what put me behind with all my classes and everything. Until I get back out there and get my feet replanted, it's going to take me at least a month to get a job. At least that's what but I do plan to get, you know, 6 months, that's a little bit of $1,300. I don't want to say, yes, I can get that done in 6
What
months.
type of work do you normally do, sir?
I normally do landscape.
How much do you normally earn?
Well, I was $400 a week. I was living in Defuni over there in Williams, and I didn't have no driver's license, so I couldn't drive.
And you live in Defuniak Springs now, right?
Yes, sir.
Okay.
I'm still at the same address. I've been there for 6 years.
How long do you think it's going to take you to get a job in landscape?
It shouldn't be very long, as long as I put my feelers out there. That's my plan.
All right. I'm going to, did the original probation require a certain amount to be paid per month?
No, sir.
It didn't?
No, sir.
It did not.
All right, I'm going to order him to pay based on what he's telling me he can earn, upon his obtaining employment, to pay no less than $50 per month toward the restitution and the outstanding court cost. And then, if there's any balance left at the end of his probation, that'll be reduced to judgment lien without a violation.
Okay, thank you,
All
Your
right.
Honor.
Thank you, Your Honor.
Thank
That way,
you.
at least some of it will get paid. All right, good luck to you. I'm sorry about your wife, sir,
Thank you.
but good luck to you. You have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you. Yes, ma'am.
Does he
The
need to get
score sheet, Your Honor,
fingerprinted?
if I may show him to defense first,
Yes. No objection.
may I approach?
Yes.
Thank you.
You may need to get fingerprinted. If so, go get fingerprinted, and then, yeah. Needs fingerprints, and then go see Officer Berry. Your Honor, Tim Gibbs on behalf of Richard Carpenter, 22 CF 3090, 22 CF 1727, 22 CF 681. Your Honor, we're asking for a continuance in these matters today. We're working on some defenses in this case, trying to get some releases that might lead to those defenses. If we could leave this set for the pretrial docket on February 27th.
No objection.
All right.
He's also on the plea day.
Yes, thank you, thank you. And for the record, we'll enter a not guilty plea on 22 CF 3090 and leave everything set for February 27th.
All right, pretrial will be set for February 27th, docket day March 6th, with jury selection March 13th, and the VOPs will travel with the new law violation.
Thank you, Judge.
All right.
Information,
Your
sir.
Honor, I'm sorry, on Mr. Bullard, since we placed him on a new period of supervision and he has to pay $50 per month toward his court order obligations, we request the supervision fees be waived.
I'm going to waive that cost of supervision. I'd rather see the money go toward some of the outstanding
Thank you.
fines and costs. Next one is Kip Fee.
Yes, Your Honor. Your Honor, Tim Gibbs on behalf of Kip Fee, 21 CF 189, 21 CF 1475. Your Honor, he has been evaluated for mental health court. He has been deemed eligible. He does need to observe that court, so we would ask to continue this to February 9th, pending that approval and admission.
No objection.
Without objection, I'll continue it to February 9th at 9 a.m.
Thank you, Judge.
Is there any way we can get a
Cameron Vance.
Your Honor, Tim Gibbs on behalf of Cameron Vance, 21 CF 1683. If I could have just one moment. Your Honor, we in negotiations with the state, excuse me, we'd like to continue this to February 9th without subpoenas to try to resolve it.
No objection.
All right, without objection, we'll pass it to February 9th without subpoenas at 0900.
Thank you, Judge.
You Ashley Cornish?
Yes, sir. Here before you on 22 CF 735.
You also have a case 2022-1803.
Yes, sir.
Right now, I'm showing that you're unrepresented, or you're representing yourself. Is that
Yes,
right?
sir.
Do you understand, ma'am, that you have a right to be represented by an attorney? If you can't afford an attorney, the court will appoint one for you.
I do.
Do you want the court to appoint an attorney for you?
No, sir.
Have you already had a hearing before a judge where the judge has made a determination that you can represent yourself?
I have had a competency evaluation, and I believe that we received that back from the gentleman that did the competency evaluation, and that I was competent to self-represent. But no, we have not done a hearing
All right.
specifically.
So
for-
what you're telling me is you've had a competency evaluation, psychological
Yes, sir.
evaluation, and that doctor determined or rendered an opinion that you're competent to proceed.
Yes, sir.
Okay, has there ever, well, let me pull the file. See, I'm showing Miss Rivers has been appointed to represent you. You're what?
I was the original prosecutor on the case.
See, it says order appointing, oh, order appointing expert, I'm sorry.
And I had requested that the court order an evaluation be conducted.
I do need to recall. Not yet.
Zeman did file a report finding that competent to proceed. There's never been a suggestion of incompetency, is that right?
I don't believe so, Your Honor.
That's the last thing I see in the court file. What is it, what's it here for today, then?
If I may, Your Honor, she should be here for a violation of probation. And those cases would be 22 CF 1879, 22 CF 1735, 22 CF 1803, along with a new law violation, 23 CF 26. At this point, if I may, Your Honor, I believe that would be convenient for all to have all the cases travel together. The new case, 23 CF 26, is currently set for arraignment on February 9th. I would request that all cases be set for February 9th. Hopefully, we could have the hearing as to whether or not Ms. Cornish should proceed pro se or not.
Well, I kind of want to get that resolved, to be honest with you. Ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, why do you want to represent yourself?
I believe that it's in my best interest. I believe that I am capable and competent to understand the seriousness of the situation, understand the contracts and plea agreements, the way that the court proceedings work, the motions that I might choose to file, that it would be in my best interest to self-represent rather than to, at this time, I, down the road, might determine to hire an attorney on my own once we get to that stage in the proceedings. But at this time, I feel like it's in my best interest and to be able to represent myself.
Do you have the ability to hire your own attorney?
Not at this time. I'm hopeful that I will have the ability once my tax return comes through.
Has she ever been determined to be indigent? Do you have any income, ma'am?
At this time, I do not. No, sir, since I'm incarcerated.
How old are you?
I would prefer not to put all of the cases together. I wish, if I may have a moment in a sidebar with you to discuss a plea agreement on the violation of probation. My other case, I plan to take to trial.
Wait just a minute. Tell me, she's got 4 cases, 3 are VOPs and 1 is a new law violation?
That is correct, Your Honor.
What's the new law violation?
Arson, first degree of a dwelling.
But that is not
Wait a minute, ma'am. Let
included
me
in my
caution you
violation.
not to say anything, because anything you say can be held against you
Yes, sir.
in a court of law.
But that wouldn't constitute as a violation of probation due to my probation was suspended at the time that charge came through,
Ma'am,
so.
hold on. What's the charge on the new law violation again? What's the charge on the new law violation?
The charge is arson.
Arson?
Yes.
That's what, a 2nd-degree felony?
I'm not, I haven't filed any information yet, Your Honor. It's either I think it's first degree.
3rd degree?
First.
First.
I'm showing 2. 22
Yes.
3 VIPs and 2
I apologize. Yes. It was under the other files.
And what's that charge?
Armed trespass.
Did you file an information in that case yet?
Yes, Your Honor. That's a 3rd-degree felony.
Ma'am, if you're convicted of these crimes, you're looking at, and then you have the VOPs, you're looking at significant prison time. Do you understand that?
Yes, sir.
And what type of experience do you have regarding representation of yourself in a criminal case?
I have represented myself on several cases prior. I have represented myself on 22 CF 1735, 22 CF 1803, 22 CF 1879. Also, other cases that have come before the court I have represented myself in the past, but I believe the best benefit for me.
And a judge allowed you to represent yourself in those other cases?
Yes, sir.
And were they resolved satisfactorily?
Yes, sir.
How much education do you have?
I have, I am college educated. I have a master's degree. I have my bachelor's also from the university, Florida State University. I have an associate's degree from OWCC, back when it was before it became Northwest Florida. My high school education. I have several more licenses, such as a realtor's license, that has since expired. But yes, sir, I have extensive education.
All right. So obviously, you have the ability to write and read and understand. That shouldn't be an issue. All right, again, ma'am, these are serious charges. You can go to prison for a lengthy period of time if you're convicted.
Sure.
And again, I'll offer to appoint a counsel to represent you if you want an attorney.
If down the road, I foresee that if I need to,
I know, you said down the road, if you feel like you want, you
Yes,
can
sir.
hire your own attorney.
yes, sir.
What I'm talking about is before down the road, I'm talking about right now.
Right now, I do not feel it's in my best interest to hire an attorney. I feel as if the state and I can come to an agreement on the violation of probation, and I wish to go to trial on the two new law violations, which are not violations of probation. So those are not included because my probation was suspended when those charges
I understand that
were
if the case goes to trial, you don't get any special consideration because you're representing yourself. You have to be familiar with the rules of evidence.
done extensive research in the law library and to make myself competent and capable of being able to handle such situations.
All right, I'll allow her to represent herself on this, on these matters. And when's the next hearing date, February the 9th?
If it's February the 9th for arraignment, Your Honor, that's for on the new law. At this point, the state is going to request to set a VOP hearing with subpoenas, with witnesses.
Okay. All right, so they want to go forward with a VOP hearing. But on the new law violation, you said you haven't filed an information on that, though.
The information hasn't been filed on 23 CF 26. On that one, no, is due the 24th, the 21 days.
All right, well, on the case where the information's not filed, I'm going to pass that to February the 9th at 9 a.m. for arraignment. And on the VOP hearings, you want a contested hearing on that?
A date in March, possibly, Your Honor?
That would be, I've got March 2nd or March 9th.
Either one works for the state. The second is fine, Your Honor, just
All
the
right,
time.
let's set it for March the 2nd at 9 a.m. on the VOPs.
We can't have a sidebar and possibly come to a plea agreement on that violation of probation then before we step out today?
I couldn't hear her, she was facing you, and I couldn't hear.
I was asking if, during a recess, if I could speak to the state about.
Well, you
a
see,
plea
ma'am, that's a
agreement.
problem when you're representing yourself.
Yes, sir.
An
Well-
attorney can speak on your behalf and can contact the state anytime they want. You're incarcerated, and that complicates the matter even more. That's
Which is why I was, excuse me, sir, I'm sorry to interrupt you, which is why I was requesting the, to be able to speak with her in person during a recess today, which was what I was allowed to do with Ms. Rivers to come to a plea agreement on cases that I self-represented before, so I know that we're able to do it if I could just simply speak with her.
Your Honor, if I may, the state is not willing to negotiate separate sentences for the VOP versus the new law. The state is going to go forward on the VOP and then with the new law subsequently.
All right. Ma'am, I know you want to represent yourself. I would strongly recommend that you accept appointed counsel.
I understand, sir. At this time, I don't believe it's in my best interest
All
to
right.
be
You don't want
represented.
it, I'm not going to force it on you, but I want you to know it's available. Okay. So we've got March 2nd at 9 a.m. for the VOPs. Got February the 9th, is that right, for the arraignment?
Yes, Your Honor, I have that.
On the new law violation?
Yes,
All right, that's all.
thank you.
Your Honor, just so the defendant is aware, I was contacted yesterday by the Okaloosa County Sheriff's Office about her case on a new grand theft auto that they are investigating, just to let the court know. That occurred while she was on supervision and on GPS, and they are requesting the GPS points to place her at the scene.
Okay. All right, you understand that, ma'am? All right. Who we got now? Joshua Ramsey, is that right? Yes, sir. Joshua Ramsey? We already did Ramsey? I don't recall that.
Yes, Your Honor, we did.
Okay. So that would bring us to James Thomas.
Your Honor, if I may have just a moment with Mr. Thomas so he can sign the agreement. And if I may approach, Your Honor?
Yes, ma'am. All right, Mr. Thomas, would you raise your right hand to be sworn, please, sir? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And you're James Thomas Jr., is
Yes,
that
sir.
correct? All right, Mr. Thomas, I have a written plea agreement. It's stated today purports to have your signature on it. Is that your signature?
Sir.
And prior to signing this, did you have an opportunity to go over it with your attorney?
Yes, sir.
Are you satisfied you've had sufficient time to discuss the case with your attorney?
Yes, sir.
Has anybody forced or coerced you to sign this written plea agreement?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
Are you satisfied with the services of Ms. Rivers, your attorney?
Yes, sir.
Okay, then he's pleading how to, let's see, he's got 2 counts of VOP in case number 1140, ending 1143, and then counts 3, 4, and 5 in case ending 1448.
Yes, Your Honor, he would be entering an admission.
All right. Court's going to find then he has in fact violated his probation. He'll be adjudicated guilty of the violation of probation. In case number 21 CF 1143, his probation will be reinstated and extended for a period of two years. And in case number 19 CF 1448, his probation will be reinstated. On both cases, the probation will be modified to include the first 2 years being on community control. He'll be required to attend and successfully complete the program at Keaton inpatient program. Once there's a bed, he's not to leave Keaton grounds without permission. All the original terms and conditions of the original probation are must be completed. In addition, he'll pay $100 cost of prosecution, $100 public defender fee, that's on both cases, and $50 PD application fee on case number 19 CF 1448, and I'll waive the cost of supervision. Sir, you have a right to appeal. This is a downward departure, too.
Yes,
it
Your
looks
Honor.
like. So I'm going to indicate it's a downward departure based upon a uncoerced plea agreement. Sir, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, want to be appointed for you, have 30 days from today to file your notice of appeal. You will need to be fingerprinted on these charges.
Good luck.
And, Your Honor, was that the first year on community control?
First 2 years.
On
Yes, sir.
community control? And we're extending from 2 years from his original termination date?
That's correct.
Two different termination dates. So the one with both those termination dates extended by 2 years, the other one was just reinstated.
What?
So one of the cases, he was on,
Okay.
in one case, he was on 5-year case.
And that's the 21. And on the Keaton, he's to remain in custody until a bed's available?
That's my understanding. He'll have to remain in custody till his bed's available.
Judge, I have an out of custody that's unrepresented, that's
Who do you
ready to
have?
plea. His name is Anthony Lyons, and he is unrepresented, but I've spoken with him about the plea, and he wishes to enter a plea today, if we may call his case.
All right.
Anthony Lyons is case number 21 CF 2553. Your Honor, Mr. Lyons has 2 VOPs before the court, 21 CF 2553 and 21 CF 2688. He was here for just a VOP. And I've reviewed the probation officer's recommendation, and I've conveyed that to Mr. Lyons. I informed him that he did have the right to be appointed counsel or to hire his own counsel. He indicated that he wishes to proceed without an attorney, and he did wish to accept the state's offer.
Which is what?
The offer would be to admit to the violations, to continue the withhold of adjudication in both cases, and extend his supervised probation by 6 months, for him to continue all mental health and substance abuse sessions that he's currently participating in at Pattinson Professional Counseling Center, to take all medications as prescribed, and to notify his therapist within 24 hours if the defendant cannot attend a session, and continue random urine analysis once a week. That would also include the court costs and costs of prosecution, and of course, all the original terms and conditions that he was previously sentenced to. So I do have the score sheet. I reviewed the score sheet with him. He scores 33 points. He's read the plea agreement and signed it, and he's indicated that he wishes to enter a plea or admission to the VOP today.
All right, sir, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And what is your name, sir?
Anthony Lyons.
All right, Mr. Lyons, before we even get into the VOP, let me advise you, sir, that you have a right to be represented by an attorney. If you can't afford an attorney, the court will appoint one for you at no cost to you. Do you want to be represented by an attorney?
No, sir.
Why do you not want to be represented by an attorney?
Well, I'm guilty of the violations, and I feel like the state has offered me a fair proposal to get through this.
You understand there may be some defenses that you have to these charges that you may not be aware of, but an attorney might be aware of?
I do understand that. Yes, sir.
Still want to go forward by yourself?
Yes, sir.
You understand, sir, that although right now the state's made a recommendation that if you violate this probation, you could end up in state prison? And you still want to go forward without an attorney? All right. I'll allow the defendant to represent himself. Sir, the prosecutors handed me a written plea agreement. It's dated today, has what purports to be your signature. Is that your signature, sir?
It is.
And prior to signing this, did you read it?
I did.
Did you go over it?
I did.
And did you understand it?
Yes, sir, I did.
Has anybody forced, coerced, or threatened you to sign this written plea agreement?
They have not.
Have you had any drugs or alcohol within the last 24 hours?
I have not.
All right, the court's going to find then that the written plea agreement to the VOPs is freely, voluntarily, intelligibly entered. I'll accept the plea of nolo contendere to the VOPs and continue to withhold adjudication pursuant to the agreement on the underlying offenses, and that's in both 21 CF 2553 and 21 CF 2688. The probation that he was originally placed on is going to be extended by 6 months on both probations. They're to run concurrent, I presume.
Yes, Your Honor.
They'll run concurrent. He'll be required to continue with his mental health and substance abuse sessions at the Patterson Professional Counseling Center. He'll be required to take all medications as prescribed, and he'll be required to keep, as I indicated, he'll be required to keep all of his therapy sessions and notify the therapist within 24 hours if for some reason he can't attend a session. He'll be subject to random urinalysis at no less than 1 time per week. He'll be required to pay the court cost as originally ordered, and also cost of prosecution, the amount of $100. And all the original terms and conditions will be reimposed on, actually, he's just being extended. So all the original terms and conditions remain in full force and effect. And you'll be required to comply with those as well. Do you understand that, sir?
I do.
All right, you have a right to appeal the legality and sense of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days to file your notice of appeal. Good luck to you, sir. You ready for Jeffrey Willis, or do you have a different?
That's fine, we can do Mr. Willis. Your Honor, this case was set for, I believe, status hearing. There was one evaluation done which found him to be incompetent. Another evaluation was done and found him to be competent. So my understanding is that the last time he was in court, there was going to be a third evaluation done. The state and the defense have agreed. Dr. Harper would be the one to do the third evaluation. As of yesterday morning, Dr. Harper had not received the order, but by the close of business yesterday, Dr. Harper did receive the order to conduct the third evaluation. So at this point, we would need another control date to give Dr. Harper an opportunity to conduct the third evaluation.
Were you all going to stipulate to the written evaluations, or you don't know at this point?
We don't know at this point, Your Honor.
All right, let's say, did he indicate he could have it done by February the 9th?
No, Your Honor. She did indicate she did have a very busy schedule, but she did agree to accept.
Well, the next date I have after that's February 28th.
Yes, Your Honor.
All right, let's set it for a competency hearing on February 28th at 9 a.m.
So there's a lady named Dr. Harper.
All right, looks like the next case
Thank you.
is Mr. Russell's case.
Your Honor, if I may, I have an out of custody, Mr. Kenneth Garcia.
That's 22 CF 2384.
Yes, Your Honor. Your Honor, Mr. Garcia was transferred up to this division from the south end. However, he has reached an agreement with the state. Judge, in this case, he's going to enter a no contest plea to a lesser included offense of possession of paraphernalia. He'll be placed on 11 months and 29 days of probation. The court would assess a $100 or $50 cost of prosecution, $220 in court costs, and $100 public defender fee. He'd have to undergo a substance abuse evaluation, treatment if recommended, perform 24 hours of community service work, as well as submit to random urinalysis.
Okay, hold on, that was,
question that,
Give me one second. Okay, that's
But it's substance abuse online,
online, okay.
24 hours community.
So, to clarify, Judge, the substance abuse evaluation was supposed to be online, so he doesn't have to do that in person. And then the reporting, I believe that was administrative level probation, Judge.
Early termination, 6 months.
And then was it early termination at 6 months if all
Yes.
requirements are complete?
And if with no violations, 24 hours community service work that he can buy out.
Who's going to monitor the community service if it's administrative monitoring?
How do we do it? Is it through JCCS?
Since it is a felony case number, it has to go through state probation. Since it started as a felony.
What do you drive down to this one?
It started as a felony, so state probation has to supervise.
Your Honor, we do have an administrative probation, but it can't have any conditions.
Well, that's why I'm asking, who's,
If they're on with us and they're placed on administrative probation, they have to pay a $50 fee up front. And they can't have any conditions because we're not supervising them, for lack of a better term.
Your Honor, if we can pass Mr. Garcia, then we can get all that figured out.
Can we reschedule this?
If we
What we would do is run a records check to see if he's been arrested. If he has, we'd
Or-
submit a violation report. If he hasn't,
In the alternative, Judge, if we could put him for January 31st, that's Tuesday, to make sure we have this. Unfortunately, even though we were given his file and the actual written plea agreement that he signed, we didn't have that today. But by Tuesday, we can make sure that we have that for the court's benefit.
No, Your Honor, it was negotiated with another public defender prior to today, and then the case was transferred, so that's the confusion. So I apologize to the court. We
I
just
do
have to reset it to finalize the terms.
Yes, Judge.
the one thing you might want to consider, if you're still thinking administrative probation, in other words, that's really an unsupervised probation.
Correct.
The one thing you might want to consider, if you keep the 24 hours community service, it'd have to be a condition that before he can be dismissed from the probation, he has to furnish written proof of that community service to the state and to the defense.
Right, and that'll be part of it.
That may be a way, with the same log, it has to be signed by the employer or whoever he's doing, not the employer, but whoever he's doing the community service work with. It would have to be signed by them, and they have to certify the hours, and then you may be willing to accept that log.
That is a very, very great idea, Your Honor. And could that be done also for the substance abuse evaluation, that at the end, whenever he
Before he
completes
can
that,
terminate.
if he provides proof that he completed that, same scenario as what you just said?
Before the probation would be terminated.
Correct, yes, Your Honor.
Here's the problem that's going to come in, and this is what you're going to have to discuss. What happens if the 6 months goes by and he hasn't submitted that? Who's going to be submitting a violation of probation? That's what you need to work out.
One second, Your Honor. The probation term is 12 months, 11/29.
right.
He can early term as 6 months if he completes everything. So in other words, if he provides all the proof of completion of the requirement by the 6th month, then he's off probation.
Well, I understood that. What I'm saying is, let's suppose it goes to 12 months, and he doesn't do, and I'm not suggesting you won't do it, sir, okay? I'm just saying, suppose it goes 12 months and he doesn't do anything, then who's going to do the VOP?
We'll also discuss that with probation, Judge.
That's the problem with administrative, non-supervised probation, but y'all working on it before January 31st.
Absolutely.
Okay.
Okay, thank you, Your Honor.
All right, so we'll pass it to January 31st at 9 a.m.
Thank you, Judge.
Morning, Judge.
Good morning, Mr. Russell.
You want to do Michael Poore? Charles Russell, Public Defender's Office. Judge Michael Poore is present and approaching. Case number is 20 CF 1775. If I could have a moment, I believe we have a written agreement.
All right.
Judge, do you want me to announce the agreement or just bring it to you?
You can just bring it to me.
Okay.
Okay, thank you.
Going to be a legitimate, uncoerced plea bargain, downward departure.
All right, sir, would you raise your right hand to be sworn?
Yes, sir.
Right hand, sir.
Sorry.
Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, what is your name, sir?
Michael Fields Poore.
Mr. Poore, I have a written agreement here, written plea agreement here dated today, has what purports to be your signature. Is that your signature?
Yes, sir, it is, Your Honor.
And prior to signing, did you read it, or was it explained to you?
Yes, sir, I did read it.
Do you have any questions concerning it this morning?
No, sir, I do not.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir, I have. Thank you.
And are you satisfied with the services of Mr. Russell, your attorney?
Yes, sir, I am.
Has anybody forced, coerced, or threatened you to sign this written plea agreement?
No, sir, they have not.
Have you had any drugs or alcohol within the last 24 hours?
No, sir, I haven't.
So what you tell me is you entered this plea freely and voluntarily of your own will, is that right?
Yes, sir.
All right. This is a downward departure.
Yes, sir.
That's correct, Your Honor.
All right, I'm going to find that the plea is freely, voluntarily, intelligently entered after defendants had the benefit of advice of counsel. He'll be adjudicated guilty of the violation of probation, and the court will reinstate him to the probation, and that probation is going to be modified to extend the probation to February 25th of 2025 under the same terms and conditions. In addition thereto, he'll be required to complete the Phoenix House probation. He'll remain in the county jail until there's a bed available. He'll complete the original terms and conditions of the probation and pay cost of prosecution of $100, public defender fee of $150, and the 48-month Department of Corrections sentence that was originally imposed but suspended will be suspended this time as well, based upon the uncoerced written plea agreement entered into between the defendant and the state. Sir, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted on this charge.
Thank you.
Your Honor, he's remain in custody until picked up by Phoenix House.
That's correct.
Thank you.
All right, now we're moving to Mr. Williams' cases. Is that
Yes, sir, Judge.
First one I have is Joseph Johnson.
That's correct, Judge. Give me just a second to move
Okay.
some stuff. Go ahead, Mr. Johnson. I'm going to be up there in just a second. Judge Jay Williams for Mr. Johnson. Judge, it looks like I'm the third attorney to get involved in his 3850. I have reviewed his motion. I need to check and make sure that the transcript that we have is a complete transcript. To me, it looks a little short for the type of trial that it was with the allegations that it has, and I also want to review a complete copy of the motion to suppress. What I'm going to suggest is, based on my experience on these things, I think we're probably looking at a half-day trial on it. So what I was going to suggest is we leave it on the docket, setting for call maybe on the, what's our pretrial conference date? The 27th, I believe, February 27th. Leave it for call on the 27th. Hopefully, we'll be ready to go by then, and then we'll just reserve one of the jury trial days, to do Mr. Johnson's 3850.
Yeah, I normally set 3850s for a separate day, but this is not my division, so I don't know how they're going to.
I just know that we're not going to have a judge from the governor yet, so we'll be dealing with senior judges, and whoever it is that has us for jury selection will have blocked off that day.
Right.
I also, and I'm new to this county, but from what I understand, we don't usually use up all our trial dates here in Crestview. So there should be a day available where if we go over a half day, we'll still be fine.
Is his 38, does he have a new law violation, or is it strictly 38?
It's strictly the 3850, Judge.
On the multiple cases?
Yes, well,
It's on one case.
there's just
It was a
one
capital.
case.
It was a capital, Your Honor. He's serving life without parole at the moment.
I thought I saw 2 cases. Oh, I'm sorry. There's a Joseph Kane Johnson, and then a Trenton Johnson. Okay.
That's correct.
Which
Yes,
Johnson is this?
This is Joseph Kane
Joseph,
Johnson.
okay. All right, let's do that. I think that's a good suggestion, because if you try to set a 3850 in the middle of arraignments or criminal motion, it takes up the whole day. So I think that's a good suggestion. We'll put it on for February. Well, actually, do you want to put it on for the pretrial conference of February 27th, or just the jury selection date of March 3rd?
Let's set it for the pretrial conference so that if we're not there, then we can go ahead and advise the court and we're not using up jury time.
Let's set it February 27th at 9 a.m. for status, with the understanding if they're ready to go, it'll probably go one day during the week of March 13th.
Your Honor, I do need to get 2 senior attorneys out of Pensacola here for that, so I'll try to go ahead and get them lined up as well.
That should also give us enough time for them to clear. Hopefully.
It's only a week or 2 away, but I'll start checking with them now, Your Honor, see if we can get this moving. It's been around a while.
Well, that's about a month off, February 27th.
I'll give them a shot.
Okay. All right, sir, we'll see you back February 27th at 9 a.m.
I tried to come out and see you yesterday, but they were in lockdown. So I'll try again tomorrow, okay?
Thank you, sir.
All right.
All right, now we've got Trenton Johnson. He's got 2 VOP cases, 22-185 and 22-1126.
Judge, we're not ready to resolve this. What I'm going to ask to do is pass it again without subs for the next VOP date.
Any objection? Any objection?
No, Your Honor.
No, No, Your Honor, no objection. I was actually trying, to communicate with probation if there was any difference in the recommendation. An effort to resolve it, in other words. May I be allowed?
Judge, we can, well, okay. Madam Clerk, when is our next set of VOPs? We don't have, or do we have any miscellaneous days, anything like that between now and then that aren't already used up? No, okay. Okay.
Yeah. Can we pass it for a second?
I don't have a problem with that. Then move on, and then we'll call you back in. Okay?
Want to recall it?
Yes, Judge, we're going to pass it for a few minutes so that she can talk with probation.
All right, what about Amanda Lawson? You ready for Amanda
Judge,
Lawson?
she's also incarcerated. This is going to be a plea. We do have a signed and negotiated plea agreement. Hey, Miss Lawson. See if I've got the state signature on it yet. I do not.
Are you Amanda Lawson?
Yes, sir.
All right, ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. If I may approach, Your Honor.
Sure.
I don't know if the microphone picked me up originally, but I did inquire of her if she had any objection to the cost of transportation, and she does not.
That was the $89 I heard y'all talking about?
Yes, sir.
All right, Ms. Lawson, I've already placed you under oath. Your attorney's handed me a written plea agreement. It's dated January the 18th, and it purports to have your signature. Is that your signature, ma'am? And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Amanda
Yes,
Lawson.
sir.
Did he satisfactorily explain the terms and conditions of the probation to you, or the plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
Just about my release, that's it.
Just about what?
My release?
Your release? Well, let's see. So you want to know about your release date, what the calculation is? Normally, the clerk does that. Have you got a calculation on that? A release date?
No, the jail does that.
Oh, the jail does that? Ma'am, I don't know offhand. I don't want to represent something to you. I mean, the probation, the plea provides for 120 days in the county jail with credit for time served. Well, it says credit for time served on the VOP only. I'm not quite sure I understand that.
That would be time served from when the warrant was served for the VOP. If
Oh.
she did any prior credit, the state's calculation for the offer did not include that. So it would be 4 months from the VOP time of arrest, which my notes indicate October 13th of 2022. So she would be serving 120 days with whatever gain time the jail gives monthly.
Okay, do you understand that, ma'am?
Sir.
In other words, what the attorney is saying is that, and I don't know because I haven't looked at the complete file, but you may have jail time before you were arrested on this VOP warrant. That doesn't count. The only time it's going to count is from the date that you were arrested on the VOP warrant. You
sir.
still want to go forward with that understanding?
Yes, sir.
All right. All right, I'll accept the plea then, finding it be freely, voluntarily, intelligently entered after she's had the benefit of advice of counsel. She'll be adjudicated guilty on the violation of probation and the underlying offenses. This is on both cases. Her probation will be revoked and terminated. She's going to be sentenced to 120 days county jail on both cases, all counts, to run concurrent, one with the other, and she'll get credit for all time served from the date the VOP warrant was served on her. She'll be required to pay $100 cost of prosecution on each case, total of $200, $100 PD fee on each case for a total of $200, public defender application fee of $50 one time. Any outstanding monetary obligations will have to be paid, or she'll be required to sign a payment plan with the clerk within 6 months of release, failing in which they'll be reduced to a judgment lien that'll accrue interest at the legal rate. And in addition, she'll be required to pay $89.16 cost of transportation to the Okaloosa County Sheriff's Department. Ma'am, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from the time to file your notice of appeal. You will need to be fingerprinted on this charge, and this is a guideline sentence.
He did.
Good luck.
And no objection to the score sheet, Judge.
Good luck to you, ma'am. Jason Moore.
Judge, I actually went out yesterday, and unfortunately, they were in lockdown, so I wasn't able to see anybody, but I did speak with Mr. Moore about his offer this morning, and he was given an offer. We had his choice of total alternatives. He's chosen the restorative supervision offer. I'm going to sign this. Give it to him to sign. Sir, do you mind if I date that for you?
Mr. Moore, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you, sir.
Judge, he entered a plea to misdemeanor originally.
First degree or second degree?
That's the first judge, it's possession of paraphernalia. Explained to him the statutory maximum on that is a year in county jail and $1,000 fine. And in terms of supervision, the maximum period of supervision is a year. This is a restore offer, so that should
Yeah, I
not
see that.
run afoul of that. He'll be on the same probation. I've also explained to him that probation typically tolls from the signing of the warrant until he's placed back on probation.
All right. All right, Mr. Moore, your attorney's handed me a written plea agreement. It's dated, actually, it's dated yesterday. And it has what purports to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it, understand it? Did you go over with your attorney? Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning? Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of Mr. Williams, your attorney?
Yes, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you've entered this plea freely and voluntarily of your own will, is that right?
Sir.
All right, the court's going to accept the plea. He'll be adjudicated guilty, and I'm going to restore him to the probation that he was originally on with the following special term and condition. He'll be required to serve 30 days in the county jail. He'll get credit for all time served. He's to undergo a substance abuse evaluation, substance abuse and alcohol evaluation with any follow-through treatment at the Bridgeway, including an outpatient, as an outpatient program, and he must contact Bridgeway within 48 hours from his release from the county jail, and he'll be subject to random drug urinalysis to determine if he's using drugs or alcohol. So you have a right to appeal the legality sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be well, he's already fingerprinted, I think, on this.
Well, and on possession paraphernalia, fingerprints aren't usually required.
Zachy Moore.
Oh, you need to talk to these gentlemen. George, this is Zachy Moore. Mr. Moore has a new law violation. The violation of probation is based solely on the new law violation. I'm going to schedule depositions in the case. The victim has filed a request to drop charges but did not provide any details about what happened or whether it happened. So I'll still need to do that. I'm going to ask that we have this case travel with the new law violation for now and set it on 2/27, which is his date for pretrial conference.
No objection.
All right, without objection, I'll set the new law violation and the VOPs for February 27th. On the new law violation, you have a docket day March 6th and jury selection March 13th, all at 9 a.m. All right, sir, they'll bring you back on those dates, okay? Good luck to you.
Thank you, Judge.
There was one that we were going to recall, two that we were going to recall. What about Trenton Johnson? Is that ready to go yet, or?
Yes, Your Honor.
It is? Okay.
Give me 1 second. There it is. Judge, first I had Mr. Bullard.
Right, that was another one. All right, Christopher Ballou.
Yeah, he's right there. Bullard, yeah. Your Honor, we do have a written plea agreement that's been executed and a score sheet, if I may approach.
Yes, sir.
No objection to that score sheet.
All right, Mr. Ballou, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You're Christopher J. Ballou, is that right?
Yes, sir.
All right, Mr. Ballou, your attorney's just handed me a written plea agreement, and it's dated January the 19th. Purports to have your signature. Is this your signature, sir?
Yes, sir.
Prior to signing this, did you read it? Did you understand it? Go over it with your attorney? You have to answer verbally, so.
I said yes, sir.
Okay.
Oh.
Have you had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with Mr. Gibbs, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you're telling me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes, sir.
All right, the court's going to find then that the written plea of nolo contendere Case number 22 CF 1716, counts 1, improper display of a weapon, count 2, petty theft. They're both misdemeanors. And case number 22 CF 3062, count 1, felony petty theft, count 2, possession of drug paraphernalia freely, voluntarily, intelligently entered after defendants had the benefit advice of counsel. The court will accept the plea on the VOPs 22 CF 1716. He'll be adjudicated guilty. This on count 1. His probation will be revoked and terminated, and he'll be required to pay required to serve 120 days in the county jail with credit for all time served. He'll be required to pay $100 cost of prosecution, $150 in public defender fees. On count 2, he'll be adjudicated guilty. That's the petty theft. He'll be adjudicated guilty, his probation will be revoked and terminated, and he'll be required to serve 120 days in the county jail, concurrent with count 1 with credit for all time served, and that's first-degree misdemeanor petty theft. In case number 22 CF 3062, felony petty theft, count 1, he'll be adjudicated guilty, sentenced to 120 days in county jail with credit for time served, and that'll be concurrent and coterminous with case number 22 CF 1716. He'll be required to pay $415 court cost, $150 public defender fee, and $100 cost of prosecution. And in count 2, possession of paraphernalia, he'll be adjudicated guilty, sentenced to 120 days in the county jail with credit for time served, and that sentence will be concurrent with count 1 and counts 1 and 2 in 2217, and it'll be coterminous. Sir, you have a right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal, and he'll need to be fingerprinted on the felony and on the petty theft and on the theft charges.
Thank you, Your Honor.
Thank you, sir.
Good luck.
Thank you very much.
Your Honor, the other person that I had asked to recall was Mr. Michael Bullard. And again, for the record, Judge, that's 21 CF 2621, 21 CF 2633. Your Honor, we're working on getting him, like I said, into the BREEP program. We're trying to confirm with BREEP that they'll come pick him up. Assuming that can happen, we should be able to get him over there. We just want to set this for Tuesday the 31st to confirm that so we can get everything wrapped up on that day.
All right. And
So
any
Tuesday.
objection?
No objection.
Tuesday.
All right, we'll pass it for January
We'll come back
31st at
Tuesday.
9 a.m.
Thank you, Judge.
Yes, sir. Ms. Rivers?
Your Honor, there are several outstanding matters that I have.
Okay.
The first one being Laura Stewart, 20 CF 505.
We should have it done Tuesday.
Ms. Stewart is present. We've reached agreement in this matter. I do apologize, I hand-wrote it, so I'll just read it to you first. The offer is, if she admits to violating her probation, it would be to reinstate her probation, extend it by 6 months. She is to report to and complete the Road to Recovery program. She must report by the end of today. And there's $100 cost of prosecution, $150 public defender fee. They would continue to waive the cost of supervision.
All right, ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Sir.
And you're Laura Stewart,
Yes,
is that
sir.
right? And ma'am, your attorney's just handed me a written plea agreement. It's dated today. Purports to have your signature on it.
Yes, sir.
And, yes, dated today. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you go over, did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
And are you satisfied you've had sufficient time to discuss the case and any theories of defense with your attorney?
Yes, sir.
And are you satisfied with the services of Ms.
Yes, sir.
Rivers, your attorney?
Yes,
Has
sir.
anybody forced, coerced, or threatened you to sign this written plea agreement?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir, just my prescription.
And what is that, ma'am? What
A
kind?
Subutex. It's Suboxone for opioid addiction.
Does that affect your ability to understand
No, sir.
what you're doing, man? Or
No, sir.
impact your cognitive?
No, sir.
Okay. All right, I'm going to accept the plea then, finding it to be freely and voluntarily intelligently entered after the defendant's had the benefit of advice of counsel. Looks like this is a guidelines plea. Was she originally adjudicated on the underlying offense, or?
Yes, Your Honor.
She was? Okay. She'll be adjudicated guilty then. I'm going to accept the plea of no contender. She'll be adjudicated guilty on the violation of probation. She'll be reinstated to the original probation that she was placed on, and that probation will be extended by 6 months. She'll be required to report to and complete the Road to Recovery program, and she needs to report to that by the end of today. She'll be required to pay $100 cost of prosecution, $150 public defender fee, and the court will waive the cost of supervision. Ma'am, you have a right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal, and you will need to be fingerprinted on this charge. Good luck
Thank you
to
very
ma'am.
much. Thank you.
And Your Honor, by what time does she need to be in that program today?
Well, I'm not sure what time they close, but normally it'd be 5 o'clock, no later than 5 p.m. Unless for some reason they close before that, and then in no case, no later than 11 o'clock in the morning, tomorrow morning.
Yes, sir.
So get there today. If for some reason they're closed when you get there, you got to get there before 11 o'clock in the morning.
Yes, sir.
All right.
Your Honor, there's also another one, Beverly Wilson, 17 CF 3073. We filed a waiver of appearance. I did provide the state with a copy of 911 calls and some civil documents.
Your Honor, the basis for Ms. Wilson's violation was a new law violation in North Carolina that has been dismissed. Therefore, we ask our VOP be withdrawn and her probation be revoked and terminated.
All right. Was she arrested on the VOP warrant?
Yes, she was, Your Honor.
She was? All right. Well, I can't dismiss the warrant if she's already been arrested on it, but what you're requesting is that the VOP be terminated?
Yes, Your Honor. Her probation supervision be terminated.
All right. Court will do that. And what was her name again?
Beverly Wilson.
Beverly Wilson. The probation that she was on will be terminated.
Thank you, Your Honor.
Thank you, Your Honor.
Judge, I had one on the docket. She may have been removed. Holly Nielsen.
She's here.
Hey, Ms. Nielsen. I think they're going to bring.
Yeah, 32. I see it now. 32. Holly Beth Nielsen, is that right? Two VOPs.
Judge, I'm going to ask to pass this one more docket. We anticipate she's going to complete her requirements by then, and that may alleviate the need to.
You want to pass it February the 9th?
She's indicating to me, I don't know that she's going to be able to get done what she needs done by the 9th. If we can pass it, I think there's one at the end of February or beginning of March.
There's one on the 28th.
Pass her until the 28th, Judge.
Any objection?
Judge, I'd just like to inquire what requirements are being completed.
Her drug, getting in her inpatient drug treatment.
Being screened? Okay, yeah, then I have no objection.
All right, at the request of the defense, we'll pass it to February the 28th at 9 a.m.
Judge, I've also been advised that Mr. Moore, after talking with probation, has decided to take the 90-day county jail option, so I've asked them to bring him back out as well, so that we can do that. Moore? Yeah.
All right, Mr. Moore, I originally placed you under oath, and I think if I recall right, if I'm remembering the right case, you entered a plea to violation of probation, and I reinstated you on the probation, and now your attorney tells me, apparently there was 2 offers made.
Yes, sir.
The probationary offer and also a 90-day in the county jail. And your attorney's indicated that you want to accept the 90 days in the county jail at this
Yes, sir.
point? Anybody force or coerce you to make that decision, sir?
No, sir.
Okay. All right, then I'm going to vacate the previous sentence that was entered in this case, and he'll be adjudicated again on the violation of probation, sentenced to 90 days in the county jail. He'll get credit for any time served, and any outstanding fines and costs or any monetary obligations will be reduced to a judgment lien that will accrue interest at the rate of, the legal rate for which led execution issue. So you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal.
Thank you, Judge.
Thank you. Good luck to you, sir.
Judge, and Mr. Johnson, the state made a new offer on him. We had tasked him. I have written that up for him. If we can bring him back out, I think we can get him resolved. Yeah, he won't be on any supervision, so there won't be any way to enforce that.
Yeah, that's the one we just did? Yeah. Yeah, I vacated that sentence, and it's just 90 days.
Yes, sir.
Okay. Yeah. All right, Judge, Mr. Johnson advises that, and Judge, I wrote this up on a regular, not a VOP form, but I've explained to him that he has the right to a hearing and that it's a violation of probation. He's going to accept the state's offer of 6 months county jail with credit for time served, and we can reduce everything to a lien.
That was the understanding the state had as well?
Yes, Your Honor, that was my offer.
So would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
What is your name?
Trayton Johnson.
Johnson.
Judge, for the record, he mistakenly signed where I would sign, and that's probably my fault. I don't have my cheaters on and pointed to the wrong spot. Yeah, that's not, you didn't make me get cataract surgery, I did.
I didn't sign
Are
it?
you good all
I
right?
don't know, did I? Sorry, no, I didn't.
I will get used to these. Oh, score sheet?
Yes.
Thank you. Score sheet's 38.4 points. That's the same score sheet that you had before, plus the addition of 6 points for the violation.
Yes,
Do you
sir.
have any objection to the score sheet?
No, sir.
There you go, Judge. No objection to the score sheet.
Okay. Okay, Mr. Johnson, your attorney's handed me the written plea. You have two cases, 22-CF, looks like 185, and then 22-CF 1126. First case has criminal mischief as a felony, then simple battery and resisting an officer without violence. They're both first-degree misdemeanors. And 1126 has grand theft auto, and this is a violation of probation for those cases and those charges. You understand that, sir?
Yes, sir.
You also understand by the terms of the plea agreement, your probation would be revoked and terminated. You'd be adjudicated guilty, sentenced to 6 months in the county jail. You'd get credit for all time served, and any outstanding amounts owed would be reduced to a judgment lien.
Yes, sir.
And is that what you want to do today?
Yes, sir.
Has anybody forced or coerced you to do that?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
All right, the court's going to accept the plea of no contendere then to those both cases, all counts on the violation of probation. He'll be adjudicated guilty. His probation will be revoked on both cases and terminated. He'll be sentenced to 6 months in the county jail on each case and each count to run concurrent one with the other. And he'll get credit for time served. You understand, sir, that the credit for time served may be different on these?
Yes, sir.
Okay. And any outstanding financial obligations will be reduced to a judgment lien. They'll collect interest at the legal rate for which what execution issue. And you have 30 days to appeal. If you can't afford an attorney, one will be appointed.
Yes, sir.
Good luck to you, sir.
Thank you.
Thank you, Judge.
Okay, let's see, I don't see anyone in the gallery. We've done all the inmates. Yes, ma'am.
Your Honor, I still have one with Mr. Gibbs, as Mr. Ronald Way. The defendant would not be present because his appearance was waived. Your Honor, the defendant, Mr. Ronald Way, the case numbers are, it looks like
21 CF 16, 21 CF 2965.
And Your Honor, there had been a motion to modify his sentence that was taken care of on 1/5/23. At that time, he was ordered to attend the Master's Touch program. He was set today for a status to confirm that he was actually in that program. I believe Mr. Gibbs has confirmed that he is in the Master's Touch program. I also have received an email to that effect from Master's Touch, so he is in compliance at this time, so that we ask that the court take no further action, and I believe Mr. Gibbs has one other.
Yes. Your Honor, on January 20th, a VOP warrant was signed for Mr. Way. However, it is identical to the same warrant from October.
I saw that.
October that led to him pleading that to enter the Master's Touch program. I believe that was signed in error. I believe it was intended to be a different type of order for his case based on this e-service that I received. We just asked the court to make sure clear for the record that there is no warrant or recall any outstanding warrants for a violation of probation at this time.
Well, let me ask you this, though. Was he arrested on, that warrant was signed, if I'm not mistaken, January the 20th?
Right.
I think, if my memory serves me
Correct.
right. Was he arrested on that warrant?
He was previously back in October or November when it came out.
I know he was on that,
Yeah.
but then another warrant was signed. It looked like a duplicate warrant.
It is a duplicate warrant, is my understanding,
On
Judge.
January 20th.
Correct.
It was a no-bond warrant. My question is, was he arrested on that second warrant?
He has not been, that's why we're asking to recall it.
Okay, then I'm going to recall that capious.
Thank you, Judge.
Thank you, Your Honor.
That capious will be recalled.
Thank you.
Thank you, Your Honor.
Okay. Any other matters for this morning?
If I may, Judge, approach with Ms. Barrickman, we do have one for the afternoon that we'd like to discuss with you before we get there.
Okay.
And then as well as with Ms. Leon, there are similar issues.
Go there.
Fiducia.